accede and exceed. These two words should not really be pronounced exactly the same. Accede means to adhere to an agreement or to become party to a treaty or a contract, whereas exceed means to go beyond or surpass. The meanings have no correlation. They are completely different. We would hear accede in a sentence like, the European Union supported Russia's application to accede to the World Trade Organization, or they were able to settle the case when the defendant acceded to the plaintiff's demand. We may hear exceed more often in a non-legal context. For instance, I got a speeding ticket when I was exceeding the speed limit while driving. Or a company might say, spending far exceeded their revenues and that caused a deficit. We can also use exceed in a positive way. For instance, you can say, her performance exceeded their expectation. Both of these words have related nouns. For exceed, we have accession. For instance, you would say, the Senate recommended accession to the treaty. And for excess, we would always say in excess of. So you could say, the company recommended that her bonus be in excess of $1 million. Now, advise and advice. They are amongst the most commonly misused words in English. Most people don't realize that there is a difference between advice with a C and advise with an S. It sounds a little bit like a Z, but it is spelled with an S. Advice is a noun. It's a recommendation. For example, here are some sentences. His advice was sound. I'm seeking your advice. Take my advice. I turned down that job on your advice. Advise, on the other hand, is a verb. It refers to the act of giving advice. So, for example, I would advise you to listen to your superiors. My lawyer has advised me to settle this matter out of court. I would advise you to listen to your teachers. I'm advising 3 students for their theses. Thank you. Now, today we have arbitrator, arbiter, arbitration, and arbitrage. Let's start with these first two, arbitrator and arbiter. They are both types of judges, but they perform in different kinds of forums. An arbitrator is a judge, but only in arbitration procedures. Those are the only forums. An arbitration proceeding is a kind of alternative dispute resolution, that is where a legal case is taken and settled out of court. And why would you take a case out of a court to settle it in an arbitration? It's done for matters of speed. Usually, it's much quicker to settle a case in an arbitration. It is also secret. So companies that have disputes where they have trade secrets that they don't want to come out in an open court, they prefer to take their cases in an arbitration proceeding, and moreover, the arbitrators often have great expertise in the subject matter. So those are all the reasons why you would take a case to an arbitration held before one arbitrator or a panel of usually 3 arbitrators. So, what is an arbiter? An arbiter is a judge of anything. Could be a judge of morals or taste. For instance, it is often said that Vogue magazine is the arbiter of fashion worldwide, or that the Film Censor Board is the arbiter of morals of all the movies and TV shows that we see. So this is a much more general word. It can also refer to a court. So it is often said that the U.S. Supreme Court is the final arbiter of all legal disputes in the U.S. So this is a word that we can use in a very general way as opposed to the very specific way in which we use the word arbitrator. arbitrage is very different from arbitration. Arbitrage is the simultaneous buying and selling of currencies or securities on two different markets in order to try to take advantage of the difference in prices. So, for instance, what an arbitrator will, for instance, buy securities on the London Stock Exchange and almost simultaneously try to sell them on the New York Stock Exchange in order to try to make money by taking advantage of some sort of a small price difference or disparities between the two exchanges. Thank you. Assignment. Assignment has both a general English meaning a task or a job, and a legal English meaning, which means a complete transfer of rights. In the legal English context or in a legal context, you should only use this definition or the term assignment when you mean this definition, a complete transfer of rights. Whereas in a license agreement, a licensor retains ownership or control over the licensed product. In an assignment, the assigner assigns away or completely transfers all of the rights to the product or the rights under a contract, and that's why you should never use the term assignment in its general English meaning in a contract. The one exception is perhaps work assignments when you are talking about employment contracts, but even then I would avoid using it to avoid any confusion on the part of the client or anyone who is viewing the document. Thank you. Solicitor and attorney. Attorney is a common term in American legal English for lawyer. Solicitor is not quite the same. Solicitor is particular to England and a lot of Commonwealth countries, and it's a particular type of lawyer. And in the UK, we contrast the term solicitor with another branch of legal profession, the barrister. Now, one of these, the solicitor or the barrister, has rights of audience at court. That means that they can go and represent clients at court and carry out the advocacy work. One of them does the preparation of the work that leads up to the actual advocacy work in court. It's a solicitor that does the initial litigation, the initial work, or the preparatory work, and generally speaking, if it's, say, a breach of contract case or a non-criminal matter, the case usually begins and ends with solicitor because most cases end in an out-of-court settlement. If the parties can't settle, then the solicitor will get a barrister's advice. The barrister is often seen as the expert in particular areas of law, and then the barrister will take the brief, the file, the documents from the solicitor that cover all the facts of the case and will then represent the client in court. The solicitor will, generally speaking, go to the court as well. In the higher courts, he doesn't have rights of audience. He can't represent the client. What he can do is instruct the barrister. So the barrister may need to ask questions of the solicitor during the court case, and the solicitor will be there to support the barrister. In the law courts, the courts of first instance, the solicitor can also represent the client and carry out advocacy work, but generally speaking, that work is undertaken by the barrister.